So the ability of the state of Texas to defend itself and its borders is getting even more complicated, and the legal battle is getting even messier, despite the fact that the Supreme Court has stepped in twice on this issue. So let's talk about what is now happening. But real quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm is an amazing company. They have amazing supplements. They can help you to get healthier, provide the supplements and a lot of the training through their app. But also one of the things I love about 1st Phorm is that they share a lot of the same ethos and culture that we support here on this channel. They love America, they love freedom, and they support the Second Amendment. So if you want to get amazing supplements and then also check out an amazing company that supports freedom, check out 1st Phorm. I will leave a link to them down below. And thank you again to 1st Phorm for sponsoring and supporting this type of content. As I mentioned in the intro, we need to talk about 2 significant cases coming out of the state of Texas that recently saw the Supreme Court get involved at an early stage. The Supreme Court recently issued a 6-3 order in the SB4 Texas border dispute cases, and that 6-3 order kept a stay in place, which essentially would have allowed Texas to continue to enforce their SB4 border law. The Supreme Court also, before that, issued a 5-4 order in a different case called the Department of Homeland Security versus the state of Texas. And in that case, the Supreme Court actually sided with the Biden administration. And that first 5-4 Supreme Court order caused even more issues in that specific area, because then the Biden administration claimed that under the order, they had the ability to once again enter that area and cut the border wire. That set up a significant clash between the state of Texas and the Biden administration, with the state of Texas now claiming that they have a right of self-defense and that they are engaging in that right to self-defense. And then also they're trying to enforce SB4, which in their eyes, in Texas's eyes, is simply them trying to enforce federal laws that the Biden administration refuses to actually enforce on their own. And this legal battle is getting even more interesting because the Biden administration is now trying to get all these cases thrown out despite what the Supreme Court just said. Now, we need to do some background on these cases so you understand what the Supreme Court did in those 2 cases and what the legal fallout has been since those 2 orders. The first Supreme Court order involved overruling a preliminary injunction that was granted by the 5th Circuit 3-judge panel. The 5th Circuit Court of Appeals and the 3-judge panel there, and that decision essentially prevented the United States Border Patrol from cutting, destroying, or otherwise interfering with concertina wire or C wire that the state of Texas had put up along 29 miles of municipal and then private land in the Eagle Pass area there in Texas. In this case, Texas originally sued the federal government themselves in a Texas federal district court, and they alleged that there was trespass and a violation of the Administrative Procedures Act, also known as the APA. In that case, the district court denied the preliminary injunction that Texas wanted. Texas then quickly appealed that denial of the injunction up to the 5th Circuit Court of Appeals. Now, along with that appeal, the state of Texas also requested an administrative stay. Texas wanted to maintain the status quo, which would prevent federal agents from being able to cut the wire at that specific location. The 5th Circuit ultimately did, in fact, grant that administrative stay. Now, as I stated, the government then sought an emergency application up to the United States Supreme Court. They asked for the United States Supreme Court to step in early and vacate that 5th Circuit stay. And what that would do is allow the Biden administration and the Border Patrol there and the federal agents to enter that area despite what the lower court said. And on review, the Supreme Court issued a 5-4 order, which did in fact grant the government's request to vacate that administrative stay. Now, after that Supreme Court order, the 5th Circuit responded by simply holding the case in the 5th Circuit in abeyance, and then they decided to kick the appeal back down to the lower court for a temporary 60-day development of more information. They wanted more evidence. This Eagle Pass case is currently being heard by the district court judge who held a hearing last week. One of the big questions out of that hearing was if the lower court is simply supposed to issue a new order, or is it simply supposed to collect the required evidence, new facts, and information that is needed, and then send the case back up to the 5th Circuit so they can issue a decision. The Biden administration and the court seem to think that the lower court themselves can issue a new order on the limited remand that has happened on this 60-day remand. However, also interesting is the fact that now the Biden administration has taken this opportunity to file a motion to dismiss the entire case, which means that now that this case has simply been remanded for a limited term for the 60 days after the Supreme Court issued their order, after the 5th Circuit sent it down for a temporary 6-day abeyance and, reevaluation and collection of information, the Biden administration is now saying, hey, we're going to take this opportunity to try to get this entire case thrown out and dismissed. Now, while that first legal battle was happening and while all this is also going on, there is a different case that was making its way through the Fifth Circuit, and that is a challenge to Texas SB 4 and its enforcement. Texas SB 4 effectively makes it a crime for an individual to violate federal law by crossing into Texas at any location other than a lawful point of entry. This bill was in fact challenged by the Biden administration. The Biden administration is claiming that the state of Texas does not have the authority to enforce this type of immigration law, and that this type of law is a violation of federal law, and that the federal government has preempted or has field preemption, that they've occupied this entire area of immigration, so Texas cannot enforce this type of law. A district court on review issued a preliminary injunction, which is preventing Texas from enforcing various parts of SB 4. Texas appealed that injunction up to the Fifth Circuit Court of Appeals, and in response, the Fifth Circuit issued an administrative stay on that lower court order, which in effect would still allow SB 4 to remain in effect and would allow Texas to enforce this law. Now, various cases have now been consolidated, and then those were sent up to Supreme Court on an emergency application, and again, the Biden administration was asking for emergency intervention from the Supreme Court. They asked for the Supreme Court to step in and remove what the Fifth Circuit did with their administrative stay. Well, then we received a 6-3 order from the Supreme Court, and in fact, it denied the Biden administration's request to vacate that stay. That means that the Supreme Court ruled in favor of the state of Texas and leaving that administrative stay in place, which would allow Texas to still enforce SB 4. Now, interestingly, in response to the Supreme Court issuing that 6-3 order, that very same day, the Fifth Circuit responded on their own, and they issued an order removing their own administrative stay. Then the day after that, they held hearings on a true stay order, and then the following day after that, they issued a 2-1 order, and what that order did is it denied Texas' request for a new stay, which means that the Fifth Circuit on review of the stay sided with the Biden administration. They denied Texas the ability to implement SB 4, at least while this case is being litigated. Then just a few days after that, the Fifth Circuit heard oral arguments on whether they will grant a preliminary injunction in favor of the Biden administration, which again would be a little bit more permanent and maybe permanently close the door on SB 4 while this lawsuit is going on. Now, from those arguments, it sounded like the Fifth Circuit would still rule 2-1 in favor of the Biden administration, but there were some concerns about if the U.S. government can seek this type of equitable relief against the state of Texas, because again, this is the federal government suing the state of Texas and suing them over a law that the state of Texas passed. There was a lot of dispute during these hearings and during these arguments, especially from a dissenting judge, Judge Oldham, who agreed with Texas that the government cannot file this type of lawsuit, cannot bring this lawsuit, and, cannot try to put a restriction on this type of law, and that the Fifth Circuit ruling in favor of the Biden administration here in this case is really unprecedented. Specifically, Texas and the one dissenting judge here focus on the fact that now the federal government and these two judges in the Fifth Circuit are allowing a cause of action that has always been limited only to private parties and private individuals. And this is outlined through a case in a famous case called Ex parte Young. Now, a basic summary of this Supreme Court case, Ex parte Young, is that it stands for the principle that sovereign immunity does not prevent people harmed by state agencies acting in violation of federal law from suing those officials in charge of the agencies in their individual capacity. And the type of relief that they can seek is injunctive relief, essentially, preliminary injunctions or permanent injunctions against this type of enforcement aspect. Now, in this case, the federal government is saying they themselves can sue state officers and agents for violating federal laws under Ex parte Young. But Ex parte Young has always been applied only to private parties. It's only been private parties suing the government. But now the government is saying that under Ex parte Young, the federal government can sue state governments. Now, what's also important for this case and what's now developed is that after this preliminary injunction hearing that the Fifth Circuit held about SB 4, there have now been requests by the court here, by the Fifth Circuit, on this very issue about what powers does the federal government have? What powers do they have under Ex parte Young? Does Ex parte Young allow these types of lawsuits? And what type of equitable relief are actually outlined in the statutes in question? The court said that during the arguments, the parties mentioned that Congress has given the federal government power under the immigration statutes to essentially seek some type of relief or maybe other types of reliefs. So, what they're saying here is, show us. The federal government is saying that they can bring these types of lawsuits. Well, federal government, DOJ, Biden administration, show us where you get this authority. Now, I still don't think the two judges are going to side with the state of Texas against the federal government. I think they are still very much in the camp of the federal government. But this issue of Ex parte Young is still a very huge issue. And a lot of these legal concepts are very important going forward, not just for what, is dealing with here with immigration and the border, but a lot of these legal concepts about the federal government suing states if a state is trying to, protect themselves or issue favorable laws. Again, that's going to have broad-reaching implications outside of other issues, including the Second Amendment. Think about issues where maybe the state here, maybe like in Missouri, when they want to pass the Second Amendment Preservation Act, well, what types of powers does the federal government have to sue the government, the state government, to stop those actions? So again, broad-reaching implications, a significant issue, something that's probably going to make its way up to Supreme Court again. And if we get any more information, I will let you guys know. So if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.